And welcome back to Court TV Live. Now let's go back to Ohio, where we are bringing you the bond hearing for defendant Ruth Miller.
A judge will determine whether to let the Amish mother out on bail after she allegedly killed her 4-year-old son at a lake last month. Miller has pleaded not guilty by reason of insanity. Let's go back inside the courtroom now. We are hearing from the lead detective, Adam Fisher, but now the defense has the opportunity for cross-examination.
Detective, good afternoon. We've met, so
yes, sir.
My questions for you, I'm going to ask a few out of order just based upon your direct examination.
Sure.
If at any time that we're conversing through this examination you don't understand something I ask or just need clarification, please just ask me to do so, okay?
Yes, sir.
All right. Now, you had brought up early on when you were talking about your training, you brought up the word crisis in relation to mental health crisis. And what does that mean to you? What do you define as a mental health crisis?
You know, a mental health crisis can be any number of things. There obviously is going to be probably a very specific definition that you might be looking for, but it can be somebody who is overwhelmed in any moment, and their responses or perceived responses occur because of some kind of lack of reality, lack of perception, really just a response to being overwhelmed at any point in time could be any of that.
In your dealings with Mrs. Miller, how would you describe her reality?
The word that I used earlier, and I think that it really hits home with this, was disheveled. Right? Her reality at the point was disheveled. Her reality at the point was really based on the foundation of religion and God and the things that He was telling her to do.
The discussion that you were having with her during the first and second interview, was that a kind of a reality different from yours, being in a normal state of mind at that time?
Yes, sir.
Now, one of the issues that you brought up on direct was Mrs. Miller asking you to make contact with her husband, Marcus, after we know it at this point, and I'd said he had already gone out into the lake and had passed, right?
Oh, correct.
Right. And
I would object to the characterization in that
I'm sorry, maybe I should phrase it.
Made that statement, we did not know at that point the whereabouts of either Marcus or Benson.
That's fair. I'll withdraw the question. Yeah, sorry. Poorly posed question. So, when Mrs. Miller had asked you to contact Marcus, she suggested that he may be at home. Is that correct?
She did at some point, yes.
Okay. And she had you, or suggested that you call his cell phone as well?
Correct.
All right. And was there anything about that interaction that you deemed to, or chalked up to her just trying to be deceitful to you?
No, not necessarily. You know, at that point, I think the details of all of the incidents were in question, and so it was really just trying to determine what the truth was, not that she was necessarily trying to be deceitful.
Might it have been that what you were being told by Mrs. Miller, in her reality, she believed what she was saying?
Might have been, sure.
Now, I told you I'm going to skip around just for a moment, and then I'll get into some semblance of order with you. You had heard the testimony before you about Mrs. Miller trying to run away from the Rangers. Do you recall that?
Yes.
Okay. And did you ever address with her why she ran from the Rangers?
No, because if I'm being honest with you, at the time that I had my first conversation with her, I had not had any contact with any Rangers, nor did I know that she had ran. And the second conversation, again, there was no discussion of that interaction with her having with the Rangers.
Okay. So as you sit here today, you don't know what her purpose in running away from the Rangers was on August 23rd?
Correct.
And just, did Ruth believe on August 23rd, at the time that you went to speak with her? I think she had said to you or it alluded to the fact that she may see her child and husband again?
Yes.
Okay. And if I were to suggest to you that she believed that her husband and child were still alive when you spoke, you would not have an opinion one way or the other?
Your Honor, I guess I would object to the extent that the questions call for speculation as to the mental state of Ruth Miller or anyone. We only know what she told us in terms of what she believed and was that delusional or not. I mean, that's something that goes to speculation as to mental state, and she's going to be examined. She's in the process of being examined by forensic psychologists to weigh in on that as it relates to competency and sanity. But in terms of a witness who is not inside her mind at the time, I think it calls for speculation.
Thank you, Eric. So, Your Honor, Section 1 on the bond issue deals with the word commit. And we talked in opening statement as to both the act and the mental state being at play. And I had stated at the time, Your Honor, in introduction of what we intended to do here today, that I would be focused on the mental state because without it, she could not have committed the crime. Hence, that is the reason why the NGRI was put into play. So mental state is an issue when the issue of no bond is raised. It may not be in other instances or if a bond had been set, but here under this statute, when we break down the word commit, mental state does come into play.
All right, I'm going to overrule the objection, maybe for reasons slightly different than what Ian has stated here, but I do believe that the statute does contemplate a consideration of the accused's mental condition, and I'm going to allow it.
Thank you. So I'll come back to that question in a minute. And detective, and is that detective or captain detective? How do you,
Whichever you prefer.
or what do you prefer? You've earned it.
There's a lot there, so I shortened to one. Captain is great.
Captain, very good. So Captain Fisher, you've got 19 years of experience, I believe, before being a detective, or 19 in total?
19 in total.
All right. And your experience with mental health matters, you seem to indicate you had training beyond that, which one would just receive from the academy. Specifically, you've got certification and training in forensic psychology.
Yes.
Okay. What other training do you have as it relates to mental health matters within law enforcement and mental health crises?
Step aside. Here we'll have more of the cross-examination of the lead detective when we return. Keep it here on Court TV.
We'll get you back to court in Ohio in just a moment, but first we have a quick update out of Memphis, Tennessee, where a jury is hearing day 6 of testimony in the Baby in the River murder trial. The defendant, Brandon Isbell, is facing a jury charged with the murders of his newborn daughter and her mother. Right now, the deputy who collected the defendant's clothes in jail is facing cross-examination. Let's take a listen together.
Did you do any bloodshot residue test? You talked about it being a forensic light test, I believe?
Yes. It's not really a test, it's just a search for it.
Okay. And you did that on Mr. Isabel, right?
Yes.
Did you do one that evening or that day on Martisha Stewart?
No.
Did you do any swabs on Miss Stewart?
No.
Did you check her clothing with that forensic light?
I had no interaction with her.
Now, we will bring you updates on that trial later on Court TV, and you can also watch the trial streaming on CourtTV.com and, of course, on our YouTube channel.
And now let's go back to Ohio, where we have been watching a bond hearing for a mother accused of drowning her 4-year-old son in a lake.
Prosecutors say that the defendant threw her son into Atwood Lake, saying that she had given her son to the Lord. It happened just hours after Miller's husband drowned in the same lake while swimming. Miller has pleaded not guilty by reason of insanity.
Let's go back inside the courtroom. The lead detective is still on the stand. He is under cross-examination by the defense.
The crisis intervention team training hostage negotiator. I am one of our only hostage negotiators here in the county. And then just continuous presentations that I give myself, teachings and others that I receive as to any type of mental health issue or crisis within the county.
All right. And do you have experience with matters where pleas of not guilty by reason of insanity or the mental state of a defendant as to whether it constitutes an NGRI? Have you dealt with those sorts of cases before?
Not specifically, no.
Okay. So this case here in the state of Ohio versus Ruth Miller is the first case in which you've been involved with that the issue of whether or not she was not guilty by reason of insanity is central. This will be the first time?
Yeah.
Okay. Now, obviously, prior to August 23rd, 2025, you did not know the family or have any understanding of the Miller family, correct?
That's correct.
And by all accounts, through your investigation, Mrs. Miller was deemed to be a good mom to her 4 children.
Right from their mouths, yes.
Okay. And you received no other evidence that would contradict that?
No.
And just to get this out of the way, and while she's not been charged with it, I just want to make sure that you have determined that Mrs. Miller was not responsible for her husband, Marcus Miller's death.
That's correct.
Can you tell me, Captain, please describe your attempts through your investigation or by way of your investigation to understand Ruth Miller's mental health history?
So the mental health history was first brought to us by her own family, suggesting that Ruth had been experiencing some kind of struggles with mental health for approximately the past 6 months. As you're aware, the Amish community addresses mental health and things like that a little differently than us as English. So the documentation or anything like that is generally non-existent. So the family saying that there was some struggles there, the family suggesting that she was seeing a doctor, potentially taking some medication. They could not provide any other information as to who that doctor was or what medication it would be for any further follow-up. And they were described to the Miller family was described to be very private, and that not even their own family would know that information.
And were you able to make any determinations as to how Ruth Miller's mental history played into the incident of August 23rd, 2025?
So the discussions that were had surrounding the previous 6 months of some mental health history were some conversations about misinterpreting of the Bible, some misinterpretation there, some believing that God was coming back very soon to get your affairs in order, and that the family and the bishop and others had had these interventions to talk to Ruth and ultimately Marcus and redirect them on a path that was more appropriate. So I think the conversations about the religious aspects of her mental health issues and then the statements made by her the day of the incident saying that God had told her or directed her to do things really coincides with that. So I think that was the same thing that she had been experiencing.
Okay. And in fact, the family and the bishop were actually very worried about Ruth's mental well-being, and Marcus's for that matter, when they did an intervention just days before being present at Atwood Lake.
Correct.
Yet they felt that perhaps a change of scenery, that going to Atwood Lake might be good for them.
Yes, and that was actually a conversation that Robert had had. Robert is Marcus's brother. Robert had. He was involved in that latest intervention, and described that Marcus was a workaholic, and that's all they ever did was work. So that may be a different, change of scenery, someplace different, a place to relax, to release some stress may be helpful.
So, with your interview of the 3 children, it was described, I believe, by the daughter, perhaps, that her mom was frantic when she came to the campground. Is that right?
Yes.
Okay. And did you seek any clarification on what that meant?
So, not when they came to the campground, but it was the day that Marcus had left in the morning, so on the 23rd, that she had awoken, and that she said that her mom appeared frantic. And when there was further discussion about that,
Michael, this to me is the important piece when they start talking about other family members suggesting she had mental health issues.
Yeah, not only that, and I'm thinking about it in terms of the trial. This is all great information for the defense.
Right, I know. They get a free look, so to speak, at what is going to be coming. All right, next we'll have more of the bond hearing for Ruth Miller in Ohio. Stay tuned. Court TV, your front row seat to justice.
Tonight, on closing arguments, an Amish mother faces murder charges after allegedly claiming she gave her son to God. We'll dig deeper with the latest from today's hearing.
Closing arguments tonight at 8/7 Central, only on Court TV.
4 dead students.
None of it seemed to make any sense.
He was evil.
What devastation.
All I can do is scream.
Victim to verdict with Ted Rowlands. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
We are in Ohio this afternoon for a bond hearing for a woman accused of drowning her 4-year-old son. Prosecutors say that Ruth Miller threw her son into the lake just hours after her husband drowned in the same lake while he was swimming. When the police arrived, they say she told them she gave the child to the Lord. Miller is pleading not guilty by reason of insanity.
All right, let's take you back inside that courtroom now. The lead detective in the case is on cross-examination, testifying about what family members had said about Ruth's mental health.
Clarified that she wasn't sure, but she felt that it was because her mom had not seen her dad and didn't know where she was. The fact that he was quote-unquote missing.
And as it related, you had said during direct examination that initially, when Vincent wanted to go with Mrs. Miller, she said no.
Yes, according to Amber, that was something that had caught her attention, was that Ruth had told him no initially.
And as it relates to time, this would have been moments before Vincent was put in the lake?
Yes.
And so what we know, at least from what was told you, that Ruth was not intending on taking Vincent, at least initially, but only after, do you know how much time passed before she decided to take him?
No, I don't. The way it would be perceived by me, or the way that it was suggested, was that Vincent had asked to go, Ruth told him no, and then decided to take him back. So whatever we can make that period of time, it did not seem very significant at all.
Okay. Did you ever receive any evidence to suggest that she had asked Vincent to go?
No.
That Mrs. Miller had asked Vincent to go to the lake or with her?
No, other than her own testimony saying that she had put him in the golf cart and transported him down there. That was the only other conversation.
So I want to talk to you for a moment about whether your investigation revealed that Mrs. Miller believed that her child was actually dead when she placed the child in the lake, okay? And so my question to you is this. You spoke to Amber,
Yes.
and Amber told you that her mom believed that the child, that being Vincent, would actually come back out of the water if they had enough faith in God.
Correct.
And for all you know, Mrs. Miller truly believed that.
Correct.
Because her reality may have been very different from yours or mine or any of the other first responders that day, not to suggest I was there.
I would object, Your Honor. I think we're going down the lines of, for all you know, that's complete speculation. We really need someone who's an expert forensic psychologist to explore those issues. So in terms of the testimony should be limited to what he knows, not for what, for all we know, this could be the case.
I'll ask.
Brian, hold on. I recognize that Adam is not an expert. I'll give you the weight that I believe it deserves. I understand if there were others who may be confused by that. I understand your point, but I recognize he has limits as to what he knows, and I'll give it the weight it deserves.
Very good.
Thank you. I'm sorry to interrupt you. I touched it.
Certainly.
Did your investigation also reveal that Ruth believed that her husband, Marcus, would reappear at some point?
Yes.
Okay, tell us about that, please.
In one brief conversation or one brief statement that Ruth had made, she suggested that they were going to the lighthouse. Remember, I spoke of the lighthouse in the marina, that they were going to the lighthouse because she was told by God to go there and she would see Vincent and Marcus again.
Okay, thank you. And it was suggested to you, was it not, by Amber, that her mom was mentally unstable?
Yes.
Okay. And did you seek clarity on what that meant?
Amber used the statement of struggling with mental stability, I think is how she put it. And she just said that Amber noticed that her mom would have good days and bad days, and that on the bad days she would sleep a lot and was very sad. That was, and again at 15, I think that was probably the extent of what she knows.
Sure. And it was described to you by Amber that on that day, August 23rd, that her mom was acting different than normal.
Yes.
Now, did you speak to the Rangers as part of your investigation?
Just in passing, quite honestly. My focus was on Ruth and then locating Vincent and Marcus. And there was a team of detectives that are out there. So, others have spoken and had conversations with them as well. I did not feel that it was necessary at that point for me to.
Now, as the lead detective, you're responsible for this case,
yes.
Correct? All right. And
still with us, criminal defense attorney Josh Schiffer. Josh, let me ask you this. This is a bond hearing, and so the defense said at the beginning of this hearing that there was no substantial risk to the community if she were allowed out. But I think this cross-examination, this testimony, hurts that position because they're saying she had good days, she had bad days, she'd sleep a lot on bad days, she might have been taking meds. All of these things to me say, wait a minute, I think she is a risk to the community.
It's not just that she is a risk or presents a risk. It's how does that relate to the rest of the community and criminal justice at large? Because remember, there are lots of dangerous people wandering around in our communities that are a danger to themselves or others, just not at that exact moment. And the courts are very clear. You're not supposed to be punished by being incarcerated pretrial. It is for specific factors that involve things like likelihood to commit another crime, safety of the community, things like that, because you're supposed to really benefit from your presumption of innocence, and being incarcerated prior to trial is a tremendous hardship that prevents you, really, from exercising your constitutional rights. So the court wants her to be out if it's appropriate. And that's really the admissions that are coming out now, that it's not appropriate sometimes, but it's absolutely appropriate other. And there's not going to be a perfect answer. The judge is going to have to make a tough call about whether even allowing her to have access to the outside world is a betrayal of the obligations he holds to the community.
You know, one of the interesting things about these types of hearings, these preliminary and probable cause hearings, is that there are lax evidence rules. And you heard there an objection by the state regarding some opinions being given by this detective who has no medical training, but the judge allowed him to talk about what his thoughts were regarding the activities of this woman and how he thought she was working mentally. Talk a little bit about those lax rules and how that helps in this process, and it's important to this process.
It's one of the most overlooked, and you're totally knocking this out of the park, Michael, one of the most overlooked tools you can use, because your case has started, your defense has started, the prosecution has started, and those lax rules and kind of less formal procedures, that's how the fishing expeditions catch whoppers. And you really can make huge hay out of the information you gain during these less than prepared initial hearings. You get the opportunity to really take advantage.
Yeah, I mean, Josh, this case, and Michael, there's going to be a lot to come in this case. We have only scratched the little tiny surface of this. All right, Josh Schiffer, thank you so much for all your great expertise today.
Folks, stick around. Coming up, more testimony from the lead detective testifying in the bond hearing for Ruth Miller. Stay tuned. We'll be right back with more right after this quick break. Welcome back to Court TV Live. I'm Michael Ayala.
And I'm Judge Ashley Wilcott. We will get you back inside the courtroom in just a moment. First, the jury is still deliberating the fate of Jeffrey Spence and the plotting parents' murder trial out of Mississippi. They deliberated for nearly 3 hours before sending a message to the judge saying they were deadlocked. He then told them to continue deliberating. Spence faces life in prison without parole if convicted of killing and robbing his daughter's boyfriend, Kirby Carpenter, back in 2022.
Spence's daughter, Caitlin, who was also his co-defendant, testified against him in exchange for a suspended sentence. Very good deal. The state and the defense focused on her testimony during their closing arguments today.
She comes out flat out and asks Jeff Spence, did you kill Kirby? What did he say? No, I didn't kill him. What are you talking about? The less you know, the better. If you say anything, you'll lose, and Nola and kill me. I did what I had to do. And Caitlin Spence testified that this was a confession.
Making stuff up to protect herself. Caitlin's making stuff up to shift the blame. Caitlin's making stuff up to earn her freedom. She's free. I think you need to bear in mind how much animosity Kirby had going on at the time, how much animosity has generated over the course of his young life. How many people wanted to do it harm? How many people threatened to shoot him in the face? Not just shoot him in the face.
Now, the jury said they were deadlocked at 6-6, so we'll continue to monitor those deliberations and bring you a verdict if and when it's reached.
Right now, let's go back to Ohio, where a bond hearing is still underway for Ruth Miller in the Amish mom murder case. A grand jury indicted Miller on 7 counts, including aggravated murder and domestic violence in connection with the death of her 4-year-old son last month.
Investigators say that Miller told them that she threw her child into Atwood Lake to, quote, give him to God. She has pleaded not guilty by reason of insanity, and now she wants out of jail.
The hearing is still underway. Let's go back to court. The lead detective, Adam Fisher, is still on the stand, cross-examination by the defense.
Are you familiar with Caden Edwards?
Yes.
Okay, and who is that?
Caden is a deputy with our office.
Okay. And it is true that Caden opined, based upon his involvement in this case, that Mrs. Miller was, quote, not in her correct state of mind.
Yes.
Okay. Did you talk to Deputy Edwards about his basis for that statement?
Yes. So the conversation that he and I had, Caden is a newer deputy here. So he and I talk frequently as life goes on or as he interacts with people on calls. And so when we spoke about this particular thing, he spoke of my words, Ruth's disjointed statements, about the Marcus being in the belly of a fish on the bottom of the lake, and things that to him did not make sense.
Now, I believe, well, if you could answer this for me, who determined that there needed to be a mental health evaluation of Ruth Miller on that day?
I can't answer that. So I know that collectively, I think that that was the push to put Ruth in the back of the squad to have her evaluated. The formal decision for a mental evaluation was done by Cleveland Clinic Union Hospital.
Now, kind of pivoting here for a moment to the golf cart, which you're aware of, the driving the golf cart. Did you look into, or as part of your investigation, that deal with the operation of the golf cart?
Yes.
All right. And do you agree with the descriptions that have been given and throughout your reports and others that Mrs. Miller operated the golf cart, quote, erratically?
Yes.
At any point, did Mrs. Miller crash that golf cart to any other part of the grounds other than just going off the dock?
Yes. So there was a conversation and a description that Ruth was observed to be operating the golf cart erratically, that at one point she had even tipped the golf cart over on its side. She had gone back to the camper to retrieve her 18-year-old sons to get them to come back and help her lift the golf cart back up, which they did, and then she proceeded to drive that golf cart.
Did she ever hit any other obstacles that day with the golf cart?
Not that I can recall.
Okay. Now, were you involved in the gathering or execution of the search warrant on August 24th?
Yes.
Okay. And can you tell me what your involvement was with the search warrants? And there will be just some specific questions, not so much as to probably cause on a search warrant, but solely as to two pieces of evidence that was examined.
Sure. So the search warrant itself was sought after by me, simply as a matter of procedure. Let's just make sure that there's nothing else in this camper that's going to give us any kind of insight into the case. So the search warrant was obtained. Our process throughout the sheriff's office, for a matter of efficiency, is there were two detectives that were already on scene. So the search warrant was signed. A phone call is made to say the search warrant has been granted, and they entered the camper, proceeded to complete an inventory, take photographs, document the things that were there. While that was happening, I responded to Atwood, and I arrived at the tail end of that execution of the search warrant.
Now, there were different tents, I believe, that were searched. One being tent, and I'd like to refer to tent 1 and tent 3.
So the tents that you're describing are tents with numbers on them. So anytime that we execute a search warrant, if we find something of interest, we will tenant with that number to then photograph it, draw some attention to it, photograph it, and then be able to label it accurately on that inventory that you're likely looking at.
Thank you. And what I'd like to talk to you about is there was a Bible that was found, that was located as part of the search.
Yes.
Okay. And that Bible was not taken, but it was merely photographed, right?
Correct.
Right. I just don't have it yet, or if it has been given over, I apologize, I have not seen it yet. Is there a photograph of the Bible in the open position?
Yes, sir, there is.
So that we are able to determine what may have been viewed last in that Bible?
Yes.
Okay. And do you recall what that was?
I don't.
That's okay. The other thing that I'd like to bring your attention to is tent 3, which were described as over-the-counter supplements. Do you recall that?
Yes.
All right. Those were not taken into evidence either. They were just photographed.
Correct.
Do we know what those supplements were or why they were being taken?
No, I do not know why they were being taken, what they were. To tell you that off the top of my head, the answer is no. It is documented specifically what those were.
Okay, thank you. Now, during your 2 interviews of Ruth, you would agree with me that the statements that she made to you were unclear at times?
Yes.
Okay. And an example of that lack of clarity would be Ruth telling you that they were in the water, they being presumably a reference to Vincent and her husband, but in heaven, correct?
Yes.
Okay. And prior to that, would you agree with the assertion that Ruth began talking to law enforcement immediately at Adwood Lake when approached?
Yes.
She never tried to deny that the son or husband were in the water, correct?
Correct.
She was clear that she did throw Vincent in the lake, correct?
Yes.
But after that, when being questioned, Ruth spent a lot of time trying to emphasize her reaction to that was that she was emphasizing that God is real.
Yes.
And that she gave her son to God because it was a test from God.
Correct.
Now, what is the word, and based upon your training and as it was used in this investigation, what does the word irrational mean to you?
Irrational to me would mean not in a normal, and that's the word response also, but not a normal way of thinking, not a common way of thinking.
And I think that you had stated, or did you state, I should ask, that it was due to her behavior and irrational thought process that Ruth was pink slipped to the Cleveland Clinic?
Yes.
Okay. And do you know who saw the pig slip at the Cleveland Clinic?
I don't.
Did you talk to any of the medical staff at the Cleveland Clinic about their treatment or determinations of Ruth Miller?
So my initial response to Cleveland Clinic, I had a very brief discussion with the doctor. I informed him of our response, the fact that there were 2 missing individuals, a few of the things that Ruth was saying, and I simply made a request to speak with Ruth before they offered her any type of treatment so that I could try to get any information. Specifically asking determinations of medical procedures or treatment is frowned upon in any kind of hospital. There have been search warrants submitted to Cleveland Clinic, so we have those official records. However, the conversations don't generally happen to us specifically.
Thank you. Now, Captain, you had spoken on direct examination about the sheet that was over Mrs. Miller's face at the hospital. It is true that Mrs. Miller kept the sheet on her face and would keep the sheet on her face until she was reconnected with her husband.
Yes, she made that statement.
All right, and she made that statement to you?
Yes.
All right. And the reason that she was going to keep the sheet on her face, or withdraw that question. She stated further to you that at some point they, and that presumed to be Marcus, she and Marcus would tell their story.
Yes.
Okay. Did you ask her to clarify that statement or give any further detail on that statement?
There was a question, to something of the sort of what does that mean, where is he? And she could not provide an answer any different than what she had already provided.
Okay. Now, you had spoken on direct examination about the bishop or family members talking about Mrs. Miller's difficulty sleeping. Do you recall that?
The difficulty sleeping conversation came from Amber. Yes.
From Amber, I apologize. So what did you do as part of your investigation to determine whether or not there was any validity to that statement and how it may have affected Ruth Miller's mental state on August 23rd?
I don't know that there was anything else to do at that point with Ruth being in custody at the jail and represented by you. I don't know that it's appropriate to have that conversation with her. So I think just the statement from Amber alone is what it is.
Okay. Did you talk to any of the family?
We need to take a break here. Up next, the lead detective testifies that Miller's actions showed she was delusional.
And the man accused of killing political activist Charlie Kirk during an event at a college campus in Utah has another court hearing. Details of what happened is right after the break. Keep it here on your front row seat to justice.
Tonight, on closing arguments, an Amish mother faces murder charges after allegedly claiming she gave her son to God. We'll dig deeper with the latest from today's hearing.
Closing arguments tonight at 8/7 Central, only on Court TV.
4 dead students.
None of it seemed to make any sense.
He was evil.
What devastation.
All I can do is scream.
Victim to Verdict with Ted Rollins. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
Before we get you back to court, here are a few other cases that Court TV is tracking.
In Utah, the man accused of killing activist Charlie Kirk appeared in court virtually today for a hearing. Tyler Robinson's newly appointed attorney told the judge that the defense does want a preliminary hearing where the judge will determine if there is enough evidence against him to go forward with a trial. Robinson will be back in court for that hearing on October 30th.
In Tennessee, the state has rested in the Baby in the River murder trial. Brandon Isabel is accused of throwing his 2-day-old child into the Mississippi River after he allegedly shot and killed her mother, Danielle Hoyle. Today, the jury saw more text messages between the defendant and his girlfriend at the time of the murders.
And in Florida, jury selection is underway in the deputy shoots girlfriend trial of Leslie Bolillo. Now, he faces manslaughter charges after shooting and killing his girlfriend, Paulina Wright, as the two were cleaning guns. He claims her death was accidental. Opening statements are set for tomorrow. Here's Court TV crime and justice correspondent Matt Johnson with more on the case.
Sloppy. That's how a Florida sheriff's deputy described the alcohol-fueled gun training session that ended his girlfriend's life on September 19, 2024. Ocala police were called to his home where they found 25-year-old Paulina Wright dead from a single shot right between the eyes. Investigators say 32-year-old Leslie Bolillo, a Marion County deputy, told them it was an accidental discharge. But he also said that he and Wright had 3 margaritas each at dinner before deciding to clean 2 firearms when they returned home. Bolillo said that Wright begged him to train her to use the weapons, so he allowed her to dry fire a Glock while pointing it at him. That's when he attempted to dry fire an AR-style pistol rifle at her. He said he'd forgotten that he'd loaded the magazine. Deputy Bolillo, who admitted to investigators that the shooting looked really bad, was fired from his job and a month later charged with manslaughter. Paulina Wright's family say that she loved music and comedy shows and was always making people laugh. She'd worked in accounting and bookkeeping and was getting ready to go back to school to be an optometrist tech.
All right, jury selection underway there, and we'll have opening statements for you when they begin. We do need to head back to Ohio now, where testimony continues in the bond hearing for Ruth Miller in the Amish mom murder case.
Talk about what their experience was with Mrs. Miller and whether she was suffering from sleep deprivation.
No.
Now, as it relates to the tests in the water with Marcus, so the tests with Mrs. Miller and Mr. Miller, Marcus, it was communicated to you that any failures to these tests were due to doubts in God.
Yes.
By Mrs. Miller, correct?
Yes.
And I would like to talk about an instance where it was communicated to you, believe that Mrs. Miller tried to actually walk on water.
Yes.
All right, do you remember that?
Yes.
Okay. What was told you and where was that?
It was in the hospital room, and it came directly from Ruth, that she was explaining that one of her tests from God was to walk on water, and that she hesitated. And that her doubt in God, the hesitation, is what caused her the inability to walk on water.
Now, we do know, at least based upon what she said, let me say, no one saw her trying to walk on water, presumably, correct?
Correct.
Right. And you were also told by Mrs. Miller that when she did try to walk on the water, she was actually wearing her clothes, correct?
Correct.
And because she was wearing the clothes, once she went under the water, it was difficult to swim because of the weight of the clothes.
Yes.
You had brought the sheriff, Sheriff Orvis Campbell, calling you, I believe on Saturday. It was Saturday, right?
Yeah.
Okay. And I'm not getting into necessarily what the job, duties were and so forth. But my question to you is, were you present for his press conference that followed the arrest of Mrs. Miller?
I was.
Okay. And Sheriff Campbell was very involved in this investigation as well, correct?
Yes.
All right. And you and he had communicated back and forth as to findings in this case?
Correct.
And it was described by the sheriff that Ruth Miller, or he opined that there was a detachment from reality. Okay, I'm not asking you as to what he said. Do you recall that being said?
I do.
Okay. Do you agree that the evidence in this case that was gathered pointed to a detachment from reality by Mrs. Miller?
I do.
And Sheriff Campbell had also opined during this very press conference that the investigation pointed to the fact that Mrs. Miller was delusional on August 23rd, 2025. Do you recall that?
I do.
And do you agree with Sheriff Campbell that Mrs. Miller, or that the investigation evidences that Mrs. Miller was delusional on August 23rd, 2025?
I do.
And Sheriff Campbell had also talked about the fact that what had been conveyed to law enforcement, so I assume you, since you did the interviews, by Mrs. Miller had panned out to be truthful, specifically what was described about Marcus, his actions, what he was wearing, and so forth.
Yes.
And was there anything during your investigation that revealed at any time that Mrs. Miller was being untruthful with you or attempting to deceive you?
No.
Now, there's some other factors that we have to address here today. You obviously did a background check on Mrs. Miller.
Yes.
All right. And that revealed no prior criminal history.
Correct.
We talked earlier on about her being a good mother. There were no reports from anyone, negative reports from anyone related to ill treatment of any of the children prior to August 23rd, 2025.
Correct.
All right, now looking through your records, you, Captain, determined that Ruth Miller was experiencing a mental health crisis as she could not provide clear information, correct?
Correct.
And what was, when you said she was experiencing a mental health crisis, as it relates to Ruth Miller, what were you trying to say in that? What was the mental health crisis that you were referring to in your report?
I think it just goes back to the words that you said. There was a detachment from reality. There was some delusional thinking, which obviously, led to the unfortunate events of that.
Here now to discuss with us criminal defense attorney Laura Yaretsian. Thank you so much for being on with both of us. Some of this testimony really stood out to me, and that is that one of the daughters, the older teenage daughter, said her mom believed that Vincent, the 4-year-old she threw into the lake, would come back from the lake. The mother also believed her husband, who had drowned, would reappear, and the child said that the mother was acting different than usual on that date. Do those facts lend towards the insanity defense?
100%. And you also have the lead detective basically supporting that notion as well. He is testifying that she was detached from reality, that she was delusional, and we also have information that she's never hurt the children before, and she's never mistreated them before. She does have mental health issues, but never been violent. Nobody has been concerned about any violence or harm to others. So yes, I can see a lot of this lending support to an insanity defense, and also some support to the defense request that she be released on bond.
Yeah, well, that was going to be my question. Does it actually help with the question of the day, which is the fact that should she be released on bond in this case? And if so, how?
This could be a double-edged sword, right? Because it sounds like someone who's delusional would be a risk, right, to public safety. However, if they can maybe request certain conditions of release to attach to the release, including that she be on her meds, that she see psychiatrists, therapists, maybe be on house arrest, be closely supervised, and as long as she's under prescriptions and she abides by specific rules and conditions, whatever they may be, right, to keep her in a safe environment and to ensure public safety, then yes, she could be released despite some of these issues, because we don't have any prior issues from her. We don't have any prior violence or any other indication that she could be violent. She was basically detached from reality, delusional. And we can tell that the argument would be that she didn't really mean to harm her child, but she, especially when she believes that the child would come back. But again, as long as you can keep the person under control, meaning with the right supervision, they can make that argument that it's safe for her to be released and she would be a flight risk.
I think she has to have the right treatment. Just quickly, I did want to ask you, a substantial risk to the community is one of the things they consider today. What about a substantial risk to herself? Is that something that could cause a judge to say, in your opinion, nope, she is staying in jail?
It's probably one of the factors that the court would consider, but of course the priority is always the risk to the community. But I'm sure that the judge will consider that too. But again, the solution is one and the same. As long as she is in the right program or is seeing the right mental health, is in the right mental health facility or at home getting the right treatment, is complying with any medications, prescription medications that she has, sees her psychiatrist, she's her therapist, and does everything that the court is ordering her, then she wouldn't be a risk to herself or to the public. Just because someone has a mental health issue doesn't mean that they're going to be, they're posing a risk. As long as they get the treatment they need, they would be fine.
Yeah, that's always the risk, though. That's always the risk. All right, Laura, stand by. We're going to step aside here for a quick break. When we come back, the lead detective testifies that when the 4-year-old victim was found, the defendant asked him if her son was with God. Keep it here on your front row seat to justice.
Welcome back to Court TV Live. I'm Ashley Wilcott.
And I'm Michael Ayala. We are bringing you testimony in a bond hearing in the Amish mom murder case going on in Ohio. Ruth Miller is charged with aggravated murder and domestic violence in connection with the death of her 4-year-old son last month. But she claims she was insane at the time.
Her attorneys are now fighting to have her released on bond. The lead detective is wrapping up his testimony. Let's go back in.
You're familiar with the term malingering?
Yes.
Okay, and what does that mean to you?
Malingering is something that's like persistent or continuing.
Did you ever perceive any of what Mrs. Miller told you or the way that she was telling you? Did you ever determine that to be suspect or suspicious or an attempt to deceive you? Anything that was not genuine?
No.
Now, you had talked about on direct interview 2, and you had said that Mrs. Miller seemed to be much more coherent during that interview.
On the second one, yes.
Yes. All right. And Mrs. Miller did not change any of her facts from interview 1 to interview 2, but she did add some facts to interview 2, correct?
Correct.
And what Ruth added to you was that she was actually talking to God on August 23rd. So she was actually having a conversation with God.
Correct.
And she had elaborated to you that God, and her words were, for the report, quote, he wanted us to do something, and that happened before midnight, coming into the critical day.
Yes.
And she had told you, Captain, that she had been witness to miracles lately.
Yeah.
Okay. Did you ask her to clarify what that meant and what miracles she may have observed?
You know, I recall having that conversation, but I don't recall what her response was.
Okay. As far as approximation of time, how long before the incident? When I use the word incident, I'm speaking of August 23rd, 2025. Do you know how long it was before that she was witnessing these miracles?
I don't.
And in fact, not only did Mrs. Miller talk about Marcus and the fish, but she also added during the second interview that God had asked her to get swallowed by a fish.
She did.
Okay. And did you have her give you any further detail on that, or were you at this point just noting what she was saying?
So I was noting what she was saying. She did explain in this particular instance that God had asked her to be swallowed by a fish, that she, again, had some hesitation, did not want that to happen, made a statement that if God wanted her to, that she would.
Right. So she actually was willing, as she told you, she was actually willing, if God wanted her to be swallowed by a fish.
Yes.
And there was nothing about that you took as her being trying to be dishonest or just disingenuous in any way?
No.
As far as physically is concerned, well, I can't say necessarily physically. The question that I have for you is, Mrs. Miller had also described to you that her head had hurt and was full of water. Do you remember that?
Yes.
Okay. Can you tell us about that statement, please?
She had made that statement after talking about the test that God was giving she and Marcus on the dock, and after they had been in the water, that's when she had said that after they had removed themselves from the water and were walking back to the camper, that's when her head was full of water and her head hurt.
Now, during direct, you had talked about the child coming back up above the water?
Yes.
Okay. And was there any sort of discussion about Ruth trying to reach out to the child?
So the first conversation, she spoke of looking at him, being questioned by God, turning and walking away. The second conversation, she said that she attempted to reach down for Vincent and could not, so turned and walked.
All right, we have some news coming out of Mississippi in the plotting parents murder trial of Jeffrey Spence. The clock has stopped, as you notice, at 4 hours and 24 minutes. And our understanding is that the jury has come back after coming back earlier, saying they were deadlocked at 6-6. They've come back again, saying that they are still deadlocked.
I'm not surprised, Michael. So that first time they came back was right before 3 hours. Now they're at almost 4.5 hours. So an hour and a half later, they're still deadlocked. I think when we learn the split, 6-6, and the judge made clear, I don't want to know who's voting for what, came back 6-6. I thought that could be a tough one to get a unanimous jury.
Yeah, I agree. But I also agreed with his point that 3 hours wasn't enough.
Agree.
Right? 3 hours wasn't enough. They spent a lot of time on this trial, wanted them to go back. He gave them what they call in Mississippi a Sharpton instruction, which is to go back and continue to try to work through this and get some sort of conclusion to this trial. But it looks like after another hour and a half, they were unable to do that.
That's right, the Sharpton instruction, just another name for what some call an Allen charge. Sometimes it's the dynamite charge. And I have to tell you, I don't think I've ever seen a trial, Michael, where the jury is told that at least once. They got to go back and keep trying.
Yeah, you know what's interesting? They didn't want to know how the split was. So had it been 11-1, they didn't want to know which way. But 6-6, it's right in the middle.
Yeah.
So it's like you got 6-4, 6 against. You know where they stand. And I think you and I agreed when he sent them back, it was going to be a difficult thing to turn 6 people one way or the other.
Yeah, I completely agree with you. I also think that to your point, you and I have talked about, there is some reasonable doubt here. Like, I do understand why this is a split jury that could definitely do one or the other. As I understand it, Michael, there's nothing happening in that courtroom yet, so it's a perfect time to squeeze in a break so that we can bring you updates from that courtroom just as soon as we know more. Stay here with us on Court TV, your front row seat to justice.
Tonight, on closing arguments, an Amish mother faces murder charges after allegedly claiming she gave her son to God. We'll dig deeper with the latest from today's hearing.
Closing arguments tonight at 8/7 Central, only on Court TV.
4 dead students.
None of it seemed to make any sense.
He was evil.
What devastation.
All I could do was scream.
Victim to Verdict with Ted Rollins. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
Street Health.
All right, folks, we want to take you back now to Mississippi for that breaking news in the plotting parents murder trial. So let's get back into court.
I believe that's all of you. All right, I've received another note from the jury indicating that y'all have still not been able to reach a unanimous decision. I caution you again, don't tell me which side, for lack of better words, winning. But what's the score? Has the score changed any?
No.
Score's not changed any? Do you feel that, and I'm sort of directing this to all of you are, not just Mr. Williams, but do you think that further deliberations, do you think any chance of any further deliberations moving the needle anywhere? Any of y'all do you think further deliberations will be any of use or not? Don't be bashful. Speak out, shake your head, whatever you think anyway. I see some of you shaking your head no. I see a lot of you shaking your head no. All right. Y'all just bear with me one just second. Well, I'm gonna let y'all go. I'm not gonna send you back if the needle hadn't moved any and you don't think there's any chance of it. If it was a 10-2 vote, 11-1, 9-3, even maybe 6-6 as far as you can get anyway. And I want to say I appreciate y'all's service. We all knew going in that this was going to be a tough case. It's going to take some of your time, and it's going to be a difficult case. I appreciate your service. Y'all be free to go. If you need an excuse for work or anything, you can stop down in Miss Nowicki's office and they'll give you an excuse. If you want to talk to anyone about your jury service, you're free to do so. If you don't want to talk to anyone about your jury service, tell them you don't want to talk about it. I don't have any reason to think they would persist in asking you questions, but if they do, you get in touch with me or one of these court officials, and we will put a stop to it, okay? I don't have any reason to expect anyway you'll have any repercussions for your jury service whatsoever. But thank you. If you need that work excuse or anything, stop off at Miss Nowicki's office. And y'all go. Thank you for your service. And y'all have a good evening, okay?
All right, Michael, the jury is leaving, declares a mistrial 6-6. Nobody moved.
Yeah, and as the judge said, that's as far apart as you can get. Perhaps had there been a different split, he might have made them go further. At first glance, 4.5 hours doesn't seem like a lot, but split 6-6, I think it was the right decision.
And twice, right? He gave him an hour and a half and still split. Let's go back in.
Y'all consult your calendars about when you may want to, if and then you want to retry this case. I got my wagon loaded between now and the first of the year, but sometime after the first of the year, if y'all wish to have a retrial, I'll get with you and get on the calendars anyway.
Yeah, the Kip County term is in February, and I believe that Pt2 has a term at the same time. So they have a special session.
We burned through one Tipper County term by this case. I don't know if we can sacrifice another term. It probably needs to be outside the normal Tipper County term anyway. That's just my thoughts anyway. We've got y'all get together and look at your calendars and see this case I want to get disposed of. I'll move something on my calendar if I need to make time for this case.
Can we schedule a time in the next week or so for the
I'll be in Lafayette County. I'll be in Lafayette County week after next. No, next. I'll be in Lafayette County starting Monday all week. Mr. Hill will be there. I'm sure somebody at the DA's office will be there. If y'all need me next week, I'll be there all week. Okay.
We'll plan to set it.
Okay.
Plan to set it at a future date at that time.
Yeah, we'll see about a future date at that time. It's this time. Mr. Spence will remain in custody at this time, and I'll hear any motions y'all might have. We need to have some discussions about the matters that have been introduced in the evidence, specifically the things of value. We'll entertain those thoughts. We can do that off the record after we have excused the jury, but we need to decide how we're going to do those things, okay? All right? Unless there's anything else, court be in recess, okay?
All right, so that's that big million-dollar question. Are they going to try him again? Let's bring back in criminal defense attorney Laura Uretzian to discuss. Laura, that's the big question now. At this point, considering how this case went, what do you think about the choice that the prosecution is going to make? If they haven't made it, they're not going to make it today. They have to think about it, but will and should they try him again?
They may, but you know what? The 6-6 is a message to them. Basically, they were only able to convince 6 out of 12. This is the definite win for the defense, and it may give the prosecution an opportunity to maybe resolve this case. Maybe it makes sense to come to some kind of a resolution on this instead of retrying it, because at least, yeah, I'm sure they've given it their best, and even their best only got in 50% of the jurors.
And you can see here, we are showing, Laura, this is the victim's mother in the middle, gray hair, crying, being consoled inside the courtroom after the judge declared a mistrial. Michael, and regardless of what I think in terms of the legalities of it, you can't take away from the emotion of it, and she lost her son. Let me ask you this, Laura. How do you feel, or how do you think the mother and daughter feel? They just saw this unfold, and they both took deals. They both agreed to 10 years, now suspended, and the daughter's was contingent on her testifying, which she did. Whether or not it was satisfactory to the state now remains a completely different issue. But what do you think they may be thinking at this juncture?
That maybe they should have took this to trial themselves.
Yeah,
that's what they're thinking. Instead of caving, because sometimes people get scared. It's not necessarily because they're guilty. People get scared because they're facing, a large number, and it could be, 20, 25 years to life, and they would rather have a number that they know at some point is going to end, and they can walk out of prison versus taking that risk. And in this case, it looks like the dad gambled the right way. He was the one who was willing to take the risk, and it was to his benefit.
Yeah, it's interesting because at the end of the day, when you see this kind of pain, it makes you realize, the difficulty that the justice system has and what it's being asked to do. But at the end of the day, Laura, this was a case where I thought the evidence was lacking. And I don't think they should bother to bring another case unless they go back and get more evidence. One of the things I was looking for in this case, if you're going to tell me that a man drove to Virginia from Mississippi, then from Virginia back to Mississippi, there's got to be some record of it somewhere, some video. Without something like that, I'm not sure it's worth bringing again. Your thoughts?
Agreed. That is the prosecution theory, right? They drove all of these miles that could have took them 30 to 36 hours. And if there's not one scintilla of evidence of that, that in itself, I'm sure, was problematic to this jury. And I would rethink my strategy, and I would probably either resolve this case or dismiss it.
Yeah. So I do have to mention this. We have learned that the mother of the victim that you saw there in the middle did collapse. An ambulance was called for her. So certainly I can't imagine the pain, and we'll stay tuned. Yep. All right, Laura Uretzian, thank you so much for joining us tonight.
All right, folks, stick around. Coming up in our next hour, we're going to take you back to Ohio for more on the bond hearing for Ruth Miller and the Amish mom murder case.
At one point, she said,
The devil got to me in the moment. But again, whether God made her do it, whether the devil made her do it, whether she's faking it, or whether she's honestly delusional, for purposes of today, it doesn't matter. What matters is there's nothing that can assure this court that she's not going to have some break again.
All right, as you heard, while the state urges the judge not to grant bond for Ruth Miller, he has suggested a hefty price for her freedom if she does win her motion. Keep it here on Court TV, your front row seat to justice.
Should I convert my IRA to a Roth? You're asking the wrong guy.
You know, financial advice should come from a vetted fiduciary financial advisor who understands your personal financial needs.
That's one intelligent donkey.
You mean a smart ass?
Find an advisor at smartasset.com.
You'll find them in cities, towns, and suburbs all across America. Millions of Americans who have Medicare and Medicaid but may be missing benefits they could really use. Extra benefits they may be eligible to receive at no extra cost. And if you have Medicare and Medicaid, you may be able to get extra benefits too through a Humana Medicare Advantage dual eligible special needs plan. Call now to see if there's a plan in your area and to see if you qualify. With the Humana Medicare Advantage dual eligible special needs plan, you could have doctor, hospital, and prescription drug coverage in one convenient plan. Plus, most plans include the Humana Healthy Options Allowance. Get $1,200 a year. That's $100 each month to help pay for eligible groceries, utilities, rent, and more. Your allowance is conveniently loaded onto a prepaid card each month. And whatever you don't spend gets carried over to the next month. Plus, you could get other important benefits. Most plans include dental coverage with $0 copays for covered preventive services, vision coverage, including eye exams and a yearly allowance for eyewear, even hearing benefits with routine hearing exams and coverage toward hearing aids. And you could pay nothing for covered prescriptions, even brand name ones, all year long. You'll also get $0 copays for routine vaccines and telehealth visits. And you'll have access to Humana's multiple large plan networks of doctors, hospitals, and pharmacies. Best of all, if you have Medicare and Medicaid, you may be eligible to enroll in a Humana Medicare Advantage dual eligible special needs plan right now. So if you have Medicare and Medicaid, call now to see if there's a plan in your area that could give you extra benefits. A knowledgeable licensed Humana sales agent will explain your coverage options, even help you enroll over the phone. Call today and we'll also send this free guide. Humana, a more human way to healthcare.
When you're at the starting line for your next event, 4imprint has the right promotional gear, bottles, bags, hats, and tees delivered on time to energize your customers and your team. Race now to 4imprint.com.
4imprint, for certain.
Want to get out of debt fast? Shark Tank's Robert Herjavec has the answer.
If you've got credit card debt or personal loan debt, you know it can weigh on you. But you could qualify to get the amount you owe cut by up to 50% just by making one phone call. It's called the Debt Clear USA program, and it is amazing. The Debt Clear USA team discovered that by working with people with $7,500 or more in debt, they can negotiate much better deals. Some settlements are as high as 50% off. This can also reduce your monthly payments significantly. And here's the best part. No more interest. And you could be debt-free in as little as 30 to 48 months.
It's just an amazing feeling to see a zero at the bottom line of all of my credit cards and loans that were taken out. It gives me hope for my future.
So if you want to see if you qualify and have the Debt Clear USA negotiators fight for you,
call or visit debtclearusa.tv. That's debtclearusa.tv.
I like winning on the field, but it's even more fun winning on Deal Dash.
Lori won $2,000 Tiffany earrings for just $1, and Joseph won an iPad for just $6. There's millions of fast auctions. So try today at DealDash.com for $50 of free credit and your first win guaranteed.
Well, Welcome back to Court TV Live. I'm Michael Ayala. Our Court TV cameras are covering the biggest cases across the nation. In Mississippi, a jury doesn't reach a decision in Jeffrey Spence's case in the plotting parent murder trial. He's charged with the murder of his daughter's boyfriend and father of his granddaughter, 36-year-old Kirby Carpenter. And in Tennessee, the state rests its case in the Baby in the River murder case. Brandon Isabel is accused of fatally shooting the mother of his child and then tossing the newborn daughter in a river. And in Florida, it's day 2 in the scattered remains murder trial for Daniel Stearns. The Army veteran is accused of fatally shooting his girlfriend and then burning her remains, but his attorney claims that he shot in self-defense. But first, we want to turn to Ohio, where we are bringing you the bond hearing for defendant Ruth Miller. A judge will determine whether to let the Amish mother out on bail after she allegedly drowned her 4-year-old son at a lake. Now, this happened last month. Now, Miller has pleaded not guilty by reason of insanity. And right now, I want to get you back inside that courtroom where the state is delivering its closing argument.
Just so for everyone's benefit, what I intend to do is decide the issue of whether the state is correct that there should be no bail. If I ultimately disagree with the state's essentially request for no bail, the issue of what is the appropriate bail then is still an issue. In your statements, if you could address both of those issues, I would appreciate it.
Okay, thank you, Your Honor. Under the statute that authorizes this court to deny bail in certain circumstances, and this would be one of those circumstances where a defendant is charged with aggravated murder. The main focus is on the safety of the community. In the context of the standard that you articulated earlier, that is, the state has the burden of proving by clear and convincing evidence that the proof is evident, or the presumption great, that Ruth Miller committed the crime of purposely killing Vincent Miller, her 4-year-old son. That she is a substantial risk of causing serious physical harm either to herself or others. And that no release conditions would reasonably assure this court of the safety of herself or others. And so, Your Honor, I began by saying this is not a whodunit, or even what did she do. This is a mother who had struggled with some stressors in her life, some mental health issues, reportedly, such that it had concerned her family and her church, and they had some intervention the morning before they left for Atwood, and felt that they had gained some headway, that it was somewhat beneficial, that it would be good for them to get away and decompress, and certainly had no idea that something like this would happen. It seems very clear that also they had a good day on the boat Friday, but that Friday night when the kids were in bed in the camper, that Ruth and her husband felt some inspiration to go out to the dock and do some tests of their faith, and they did that. And then later in the morning, they came back to the camper, that she reports that Marcus left again on his own volition to swim to the sandbar and never came back, is what she, and that was the last time she saw him, is what she said. She ends up going out to the pontoon. She says that she witnesses his clothes left on the pontoon. The same clothes that responding officers also saw on the pontoon. And the same clothes that Marcus Raber said at approximately 6:30 a.m. he saw Marcus Miller wearing when he confused him to be Bobby Miller. But when Ruth went out there, her husband was not there, is her report, and that she began to spiral. And she went back and she got her son Vincent, and she took him to the dock. And she's very clear in her statements to Adam Fisher at the hospital as to what she did. It may have been somewhat vague in the field to the initial responders that I threw him in, that I gave him to God, but she was very clear with Adam at the hospital. And that is, she said that she felt she should throw him in the water, that she threw him in, and he came back up to the surface and looked at her, and that she questioned whether she should be doing this. And her statement to Adam at the hospital was that she felt that God was telling her to walk away, and she turned around and walked away. Now, then she went back and got her other children and brought them out, had them perform some tests, that they were praying intently near the kayak dock, that they got into the golf cart and then raced down to the bistro and over the rock embankment and into the water. And that's when the 911 call came, and that's when we get involved. At the scene of where she wrecked the golf cart, it's very clear that she was uttering many things, such as her husband and son are in the water, that she gave them to God, that it was concerning. The Rangers directed her to show them where that was, and she began with the children to walk away from that area. But quickly that accelerated into a dead sprint, according to the ranger. And they essentially got away from the Rangers and the one deputy who had responded. And Ruth was missing for nearly 30 minutes and found eventually lying face down in high weeds. And when she is recovered, she continues to talk about these irrational thoughts, about that she was doing the will of God, that she had given her husband and her child to God, that she threw her child off the dock, is what she said in her excited utterances when she was recovered from hiding or from lying down in the high grass. But it's interesting that she's missing for a half hour, that she's has a lot to say to bystanders and to initial responders right after the crash, that she has a lot to say to initial responders and bystanders when she's recovered from the high weeds, but she's remarkably quiet and undetected for 30 minutes until she is found. There's no question who done it and what she did. And the defense has made some remark of whether she committed the act, as that word is construed in the law. I would urge the court to take into consideration the law as it relates to natural consequences. And juries are instructed on this in many cases. A defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act or failure to act. The defendant is responsible for the natural and foreseeable consequences that follow in the ordinary course of events. from acts or failure to act. So her act was to throw her son off the dock, her 4-year-old son, who couldn't swim well, if he could swim at all. That was an act, and there's a natural consequence to that act. Whether she was delusional or whether she was malingering, at this point, it really doesn't matter. That will be determined later at another juncture, I presume, when we determine competency and insanity. But for purposes of this hearing, it doesn't matter whether she was honestly delusional or whether she was malingering. The natural consequences of throwing a 4-year-old into the water is that he'll drown if not saved. And then when he resurfaces and he looks at her, and then she decides, for whatever reason, to walk away, the natural consequence is that she acted and she had an omission as well that caused his death. And the natural consequence is that that's her purpose. She's imputed with that purpose. So that's why I say this is not a whodunit. I think the proof is overwhelming whodunit and what she did. The real question is whether there are any release conditions, if you were to release her into the community, that could assure this court that she's not a risk of serious physical harm to herself or others. Now, we have just received both the defense and the state medical records from Cleveland Clinic Hospital. And you've not heard anyone testify from Cleveland Clinic that they can assure you that there are some measures that could be put in place to safeguard not only Ruth, but her family members and the community. You've not heard that. That's not on the record. In fact, I think I can say that the records are fairly voluminous at both Union and Marymount, that she said a lot of things to a lot of hospital personnel. A lot of things consistent with what's been said here today and what she said to investigators and even more. That while she was in hospital care, she was generally regarded as polite and compliant, if not pleasant at times. And that she expressed that she couldn't believe what she did. At one point she said, the devil got to me in the moment. So, but again, whether God made her do it, whether the devil made her do it, whether she's faking it, or whether she's honestly delusional, for purposes of today, it doesn't matter. What matters is there's nothing that can assure this court that she's not going to have some break again based on whatever, based on a lack of sleep, based on misinterpretations of the Bible, based on something beyond what we're even discussing here today. It doesn't matter. What matters is, can she give some assurance to the court that this isn't going to happen again? And, Your Honor, given the gravity of what happened here, there is no ankle monitor that's going to assure the court that she is not a harm to herself or her family members.
All right, before we take a break, folks, the judge has declared a mistrial in the plotting parents murder trial for Jeffrey Spence in Mississippi. 3 hours into deliberations, jurors told the judge that they were deadlocked, and then he sent them back to continue deliberating. They were 6-6 at that time. After another hour and a half, they returned again, saying they could not reach a unanimous decision, still at 6-6. Now, Spence was accused of killing his daughter's boyfriend, Kirby Carpenter, in December of 2022. Carpenter's mother, she was in court and testified at trial. She became very emotional after the judge's decision and then later collapsed, and an ambulance had to be called. Meantime, Spence was not released. The judge ordered him to remain in custody while prosecutors decide if they will retry him. All right, coming up next here on Court TV, the state finishes its closing argument, and then the defense makes an impassioned plea to the judge to grant Ruth Miller pretrial release. The bond hearing continues after this break. Keep it here on your front row seat to justice.
Tonight, on closing arguments, an Amish mother faces murder charges after allegedly claiming she gave her son to God. We'll dig deeper with the latest from today's hearing.
Closing arguments tonight at 8/7 Central, only on Court TV.
All right, folks, let's head back to Ohio for the rest of closings from the state in the Amish mom murder case of Ruth Miller.
There's no secured facilities besides the jail and besides some state hospital that either competency or sanity might dictate that she has to go to. But that's a procedure for another day. Short of a state hospital to be determined another day or the jail facility, there's nothing that can assure us that she will be safe in our community, to herself, her children, or others. So, Your Honor, getting into issues of why she did this, I think gets beside the point. The point is that she did it. What she did was horrible, and if it can ever be determined by forensic psychologists and by finders of fact in this court why she did it, that will be an issue for another day. At this point, Your Honor, I would urge the court to deny bail because no reasonable assurance can be given to this court that she can be safe to herself or others in this community. Now, one thing that the no bail statute doesn't address, but that just general considerations of bail does address, is flight risk as well. So, Your Honor, if you were to set a reasonable bail, I would urge the court to set a very high cash bail. At least $1 million bail. Because in conversations with the family, they have resources, and they could make a moderately high bail. They might make a high bail. And I would say this. She has 3 surviving children who love her. And who want to be with her. I don't believe she could provide any assurance to this court that she could not just leave the jurisdiction of the court, especially given the high stress that she's under at this point, and just really disappear into obscurity. Yes, she has ties to this community, but we don't know where she might have extended family. So I think that Your Honor can reasonably take into consideration risk of flight. And I would also say this, that I want to be a little measured here, but her teenage children, okay? There is a counselor involved with them, with at least some of them. And without the input of a counselor as to a good plan for having some kind of contact, I think the most prudent course is for the court to order no contact with the surviving victims here. Until further order of the court, and mainly until some mental health therapist who is familiar with the situation can endorse such a track or such a plan. So, first request, Your Honor, is that you deny bail. That whatever made her did it, her stressors are even higher now, and she cannot, being under indictment for this, and she cannot give any reasonable assurance to the court, and there's not been made any, through testimony, any articulation of a reasonable assurance that she'll not be a harm to herself or others. Therefore, Your Honor, I'd ask that you deny bail, that you order no contact with the surviving victims, and in the alternative, a very high cash bail. Okay, thank you.
Thank you. All right, so that does it for the state. Let's bring in our guest this hour. Attorney and former prosecutor Randolph Rice is with us. Randolph, the state's attorney there made a compelling and cogent argument, I thought making some great points to this judge. I'd love to get your reaction.
Now, Michael, I thought he did a great job, and good evening. I thought he hit the two main parts there, which are, one, she is a danger to society. She could be a danger to other children or to other individuals. Or two, she is a danger to herself. And no telling what, obviously, mental health condition she may be suffering from, that she ultimately could believe that causing harm to herself would be a good thing, which obviously it's not. So I think that seems to be the thrust of the state's argument to keep her in jail.
Yeah, now he also asked for that no contact order. You heard that there are 3 teens still alive. They were under threat that day as well. She was stopped before she was able to do anything with them. But I think she was planning a similar thing for them with that lake. And you can't be 100% sure, but clearly that was seemed to be the direction she was going. Talk to me about that, because he's saying to him, you know, we have this, we don't want bail for this person, they should be kept in. But in the alternative, number one, he wants high cash bail if the judge determines there should be bail, but also, regardless, he wants that no contact order. What do you make of those?
Yeah, the state always is going to argue in the alternative. So if you do let her go on a very high bail so she can't post. But that no contact is very important. And remember, that stays in place even if she's in jail or if she's out of jail pending trial. And that's important because you don't want defendants contacting potential state witnesses while the trial is pending.
Absolutely, because it goes to that as well. Not only is she their mother, they are potential witnesses against her. We heard a lot about what they had to say about Mom during this hearing. All right, Randolph, stand by. I want to get back inside that courtroom now. We want to hear what the defense has to say, some of their arguments. Let's get back in.
Thank you, Your Honor, for allowing us to explore the issues here today thoroughly. I would submit that if there were not instances where someone was charged with murder, if all people who were charged with murder, aggravated murder, should be held, then the statute would say shall. It's the fact that the shall provision, which we find so spread through all of our rules, but the fact that shall is not there means that there are instances where people commit these offenses where they still should get a bail. And as tragic as this is, today showed us that there were really circumstances here that point to the fact that we're not dealing with a cold-blooded murderer who poses a threat to those around her. And this would not have occurred, certainly, Your Honor. What we hear today is most likely, and I agree with the prosecutor that there will be further evaluations and so forth. But I think it's a safe statement to make that this would not have happened but for significant mental health issues. What they were, that'll be detailed on another day. But the fact that they existed, everyone, even in their career-based experience, felt that there were mental health issues present. And so the questions that arise when I look at Revised Code Section 2937.222, again, I hone in on the word committed. And I'm not going to get into you understand why I said that before. But I bring in all of the facts that we heard today about all of the...
All right, Ian Friedman there, the defense attorney, may look familiar to some of our longer-time viewers at Court TV. Was a regular guest at one time here on the network. Right now, we'll take a break. When we come back, we'll hear more from Ian Friedman and the defense when we return here on Court TV. Welcome back to Court TV Live. I'm Michael Ayala. We are bringing you the bond hearing for the defendant in the Amish mom murder case in Ohio. Ruth Miller is charged with aggravated murder and domestic violence in connection with the death of her own 4-year-old son last month. But she claims that she was insane at the time. Her attorney is now fighting to have her released on bond. Let's get you back to the defense's closing argument.
Mental health, ailment, whatever the word may be, that's my word, that she was undergoing. So where best to treat that would be at a facility that treats mental health illness. And I totally agree with the prosecutor that there's been no evidence to suggest that how she acted at the hospital. We heard about what was heard and so forth. But the burden being on the state is that they had to show that there is no other reason. Not that it had to be shown that there were alternatives, but it had to be shown by clear convincing evidence that there were no release conditions that would reasonably assure the safety of that person in the community. There is nothing to state that she did not do well at the Cleveland Clinic. There's nothing to state that at all. That burden rests with the state to show that if it did. She never posed a risk before. By all accounts, this was an isolated incident that came as a result of what was going on in her mind. I think to say that there are no release conditions, I think that's a little too far because she did do fine. There's nothing to suggest she didn't at the Cleveland Clinic. She's doing fine now. And so when she's getting the care, when she's getting the regimen, when she's getting medication, and if she were able to get the care of mental health professionals to the level that she's going to need, because we're talking about conduct that quite likely constitutes that of not guilty by reason of insanity. And with all due respect, the jails in Ohio and throughout this country don't have the resources to treat that level of illness. The facilities do. So you would ask, Your Honor, what do we suggest? I don't suggest that Ruth be just released back to the public. I do not suggest that an ankle monitor is sufficient. I don't believe it is until Your Honor is supplied with additional information. That information would come from an inpatient facility. That an inpatient facility could include institutions like going back to, well, actually, what I'd like to do, Your Honor, is give you the general, what we're seeking, and if the court is amenable to it, what I would ask to do is to notify the court under seal of exactly the places that she would go. It just makes more sense, because part of this is also, once it's determined appropriate by the inpatient treatment, and that's after they have substantiated medication and the counseling, that should be stepped down only by court order to release with home arrest, not just GPS monitoring, and also that in combination with outpatient treatment continue. So what this looks like, again, because I did say that rather confusingly, is going to inpatient treatment, whether that be the clinic, Recreate Ohio, Highland Springs, Sunrise Vista Behavioral, that can be done with an ankle monitor, if that needs to be. And then if there comes a point where the hospital says that she is stable, that she does not pose a threat, and we have the battery of documentation to support that, we would come back to the court to ask for movement from there to address with family members. Again, we'll disclose that if the court would like it now, or I can certainly put it under seal, but locally family members with house arrest and with continued outpatient treatment.
All right, we'll take a break here. Coming up, we'll have the judge's decision and an update on the chaos after a mistrial was declared in Mississippi in that courtroom. So keep it here on Court TV, your front row seat to justice.
Tonight, on closing arguments, an Amish mother faces murder charges after allegedly claiming she gave her son to God. We'll dig deeper with the latest from today's hearing.
Closing arguments tonight at 8/7 Central, only on Court TV.
All right, I'm going to get you back to Ohio in just a second for the judge's decision. First, I want to take you to Mississippi, where a medical emergency happened in court after the judge declared a mistrial in the murder case against Jeffrey Spence. The victim's mother was overcome with emotion, openly wailing in court before collapsing. And Court TV field producer Tiffany Smith was there and joins us live on the phone with details on that chaotic scene. Tiff.
Hi, Michael. Yeah, a pretty raw and emotional day at the end of court today. There was a mistrial in the Spence case, and after that mistrial was declared, the mother of the victim, Miss Maddie Jane Jones, had a emotional outburst. Following that, she collapsed and passed out. Paramedics were called. Thankfully, I've just gotten word that she is okay, and she's being treated at a local hospital, but pretty chaotic. Emotions were running high. A lot of folks could not comprehend what was happening in the courtroom. There were a lot of folks who were crying because we didn't know exactly what was going on, but thankfully she is okay.
Thank you so much for that report. And remember, Maddie did, in fact, testify at trial, as did a number of other family members as well. And remember, the case is not completely over yet. Prosecutors are still trying to determine and will determine in the coming days whether they will try Jeffrey Spence again. We'll have to wait and see on that decision. Of course, we'll bring it to you when we find out. All right, let's go back inside that Ohio courtroom now for the judge's decision on whether to grant Ruth Miller bond for pretrial release.
You have to consider the following. There's four of them. They're kind of long, but I think it's worth going through them. Number one, the nature and circumstances of the offense charged, whether the offense is an offense of violence or involves alcohol or drugs. There's no indication here that alcohol or drugs were involved, but there is also no dispute that murder and felonious assault are offenses of violence. The weight of the evidence, number two, against the accused in this case. I'm going to conclude that the weight is significant against you in this matter, that in fact you carried out the offense of felonious assault and in this case, at least for today's purposes, murder. Three, the history and characteristics of the accused, including but not limited to the following. I'm to consider these. And I have your character, to the extent that I can, at a bail hearing. Character, physical and mental condition, family ties, employment, financial resources, length of residence in the community, your community ties, past conduct, history related to drugs and alcohol, and criminal history of the accused. I know of no criminal history. I don't know of any reason to believe you don't have a strong connection to the community. I've taken that into consideration. I've taken into consideration the fact that a lot of people, well, I shouldn't say a lot, a number of people, at least who have testified here today, they would at a minimum had raised an eyebrow as to your mental condition on the date in question. I am also to consider whether at the time of the offense, whether or not you were under supervision of any point in time. You clearly were not being supervised by another court at that time. So I've considered it. Lastly, the nature and seriousness of the danger to any person or the community that would be posed by the person's release. Those apply to whether or not you pose a substantial risk of serious physical harm, whether the state has met that burden. And Ruth, in my assessment in this matter, I am coming to the conclusion that the state has presented clear and convincing evidence that you do pose a substantial risk of serious physical harm to any other person or the community, and that there are no release conditions that would reasonably assure the safety of that person in the community. And I'm going to tell you why. In this case, you were told, at least by the evidence that I've heard so far, that there were people in the community who had concerns. The bishop was concerned. Your family was concerned. They tried to intervene. They tried to have you listen to reason with them. And I think by clear and convincing evidence, you did not listen to the bishop. You did not listen to your family. And Ruth, I don't think you'd listen to me if I put conditions upon you in the community. You listened in this case to what you believed God was telling you to do based upon the testimony that I've heard to this point in time. And that does not leave me assured that you will follow my conditions. For that reason, I am going to deny bail in this case. I'm going to have you held in the Tuscarawas County Jail while this matter is pending. This statute, though, it does, and regardless, the issue of bail is one that could be reviewed. And I don't mean to plant any type of false hope that I would somehow change my mind and have a personal recognizance. That's not what I'm trying to do here, Ruth. But really, for the first time, at the end of this hearing, I heard for the first time that there may be a place that you could go to other than the Tuscarawas County Jail for which the community could be assured of the safety of others, and that you would not pose that substantial risk of harm to others. And I'm open to that idea. I simply know nothing about that idea at this time other than it was floated at the very end of the hearing. So that's my ruling at this time. But as I do in any case, regardless if it's aggravated murder or a low-level felony, I believe the issue of bail is always open to review. And if there is a suggestion, if there's more than a suggestion, there's a plan in place that would give me that confidence that I don't have right now, I would consider it. If there's nothing further, the issue of the no contact line. I'm sorry, we are just going to have to agree to disagree on this issue. I know you've asked before, but my opinion is this: when someone is being held without bail and on aggravated murder, I only want to put an order in place that I believe I can enforce. And if she were to make phone calls from the jail, I feel as if there's nothing more I can do to her. She's already being held without bail, facing life in prison. So I don't know what teeth, I can put into it if someone doesn't listen to me. If someone, though, persists in calling from the jail and you believe they are in some way interfering with this case in some way, I would consider that placing an order with the jail to not allow phone calls to be made in general. But at this point in time, I just simply don't believe a no contact order when there is no bail is enforceable. Anything further?
Just two issues. Your Honor, please just note our objection for the record.
Noted.
Secondly, as far as transcripts are concerned, how would you like us to?
I want to direct that to
Perfect.
Ms. Hyatt.
All right, thank you very much. Have a good week.
Okay, thank you.
Thanks, Judge.
All right, so as we just heard, Ruth Miller denied bond. And as for that no contact order, the judge said he's not going to put it in place because he has no means to enforce it. So if she wanted to speak with or talk to her children on the phone, sounds like she will be able to do that. Still with me, attorney and former prosecutor Randolph Rice. Randolph, your reaction to the judge's decision. I was a little surprised by that last part. It sounds like he might have wanted to put some sort of no contact order in place, but said he had no real strength to enforce it. I think maybe there was some compassion in there as well, saying, look, she can talk to her children. She's already being held without bail.
Yeah, that's one possibility, Michael. I will say this, and I've had this happen to me hundreds of times, that when a judge rules against me and my client so badly, it just goes horribly for me and my client, oftentimes judges will give you a win in a really insignificant way by saying, well, you know what, I'm going to grant the defense's motion to allow you to still have contact. And, your client may think you may have helped out and won a little bit on that hearing. So maybe it was just the judge throwing the defense a bone here.
He threw them another bone, Randolph, which I found interesting. At the end of Ian Friedman, the defense attorney's argument, he talked about some kind of facility that could not put her in jail, have her out of jail, but also in some way protect the community. The judge didn't have any information on it, so he couldn't rule on it, but he did say it sounded like he was open to some evidence presenting or some information about this type of place. He said he didn't want to get anybody's hopes up, but it was possible that there might be some opportunity under the right circumstances for her to be released to this type of facility. Did you hear that as well?
I did, Michael, and you were very astute to pick that up, because that's another good point there, good bone that the defense got. Now the problem is a lot of times is that when your client gets arrested and you've got this hearing, it's very difficult to get all the pieces in place to have your client accepted, and the bed and the transportation. And so what the defense is probably going to do is they're going to go back to these facilities and say, hey, can you come evaluate our client? Can you set up all the moving parts to get her to your facility? And then we'll take these reports back to the judge for another bail review and maybe get her transferred for mental health treatment.
So what do they have to do? I mean, that's obvious part of it. Do you think, and again, I thought the judge was pretty clear, look, don't get your hopes up too high. If they bring back enough medical information that this would be the right facility for her, the community they could ensure some sense of community safety for the community. What are the chances in your mind that a judge might allow her to go there for the time being as she awaits trial?
Yeah, I think that's probably the better chance, Michael, is that the defense wants to get her at a facility, because my guess is they're gonna make the plea of not guilty by reason of insanity, and so that will be her ultimate endpoint. Why not get her there earlier, start treating her, and then you have something to present to the judge in mitigation, and at least a place to say, hey, look, judge, when you're going to sentence her and send her to somewhere, this is where she should be. This is where she's been for the past 6 months, and it seems to be working.
And talk about the ability to prepare for trial. Oftentimes you'll hear defense attorneys say how difficult it is preparing for trial while someone is in jail under circumstances like this. Does it get easier when they're in a facility like that? You have doctors working with her. I imagine it would be helpful in many ways.
It can be easier in some facilities, because if you're in the jail, typically you're between a big piece of bulletproof glass. You don't have contact. Some jails have computers in them, so you can load information in the computer with a screen and you can show your client. If a facility like this does not have that, that can make it difficult. But at the same time, some of these facilities are so relaxed or laxed that you may have a private meeting room, which is ideal when you're meeting with your client, to sit down, lay everything out, and have those private conversations.
All right. Well, Randolph, thank you so much for that. Truly appreciate it.